Advocate Zandile Mshololo has asked the court to postpone the cross-examination of state witness Thabo Mosia to allow her to read a second docket which has come to light that actually implicates Kelly Khumalo and the others who were in the house of being responsible for Senzo Meyiwa's murder. Now, in the second docket, the Director of Public Prosecutions South Gauteng wanted Longwe Twala, Kelly Khumalo, Gladness Khumalo, Zandi Khumalo, Tumelo Madlala and Mthokozisi Twala, along with Maggy, Phiri, to be charged with murder and defeating the ends of justice. Now, we're now joined by Afriforum's head of the legal department, Advocate Gerrie Nel, for his observation of how this case has unfolded. Advocate Nel, good to see you again. Welcome to Morning Live.
Good morning.
So, just to confirm, with regard to your involvement with this case and the Meyiwa family, can you just clarify for us where that is at the moment?
At the moment, I'm acting on behalf of the sisters and the mother of the deceased in this matter. I'm acting on a watching brief. So we're supporting them through the proceedings, and we ensure that justice is done. But may I just say that this is another chapter in the inept and unprofessional handling of this matter by the criminal justice system as a whole. So I hope that I'll be able to place it a bit more in perspective, and by placing it in perspective to indicate that we have a matter before court. As far as that matter is concerned, I believe that there's a strong case. It's a case that the accused will have to answer to. And what all the derivative issues, I think we should just place into perspective so that people understand it in the way that we do.
So let's do that, because I guess first and foremost now, after yesterday's developments, by no means new, because we've heard of the existence of the second docket for quite some time, but yesterday, formally in court, where the legal representative for accused number 5 actually was very strong in basically admonishing the state for only furnishing her with that second docket yesterday. So first docket, second docket, is this unusual to begin with?
Well, yes, I think it's unusual, but I think we should just go back a while. When we got involved in 2019 when there was no communication from the police or the NPA with the family. The first things we did is we had our reservations about the office in Johannesburg of the DPP, of their handling of the matter. The matter was then transferred to the office in Pretoria of the DPP. We also had our concerns about the investigating team, and the investigating team was then replaced with the current investigation team. But these issues about a second docket and 2 teams working parallel and reporting to different people within the police structures has been known to us for a while. We wrote a letter in September where we indicated that there are 2 investigating teams, 8 September 2020, where we're indicating there are 2 investigating teams and that should be dealt with by police management. And what we know is that seemingly in 2019, a Colonel Buthelezi, from the letters that I've seen, opened an investigation into the murder and investigated that murder to run parallel with the investigation of the murder matter. Now, that is unusual. But that it's only unusual if evidence is then obtained in that case docket, and that evidence is never shared with the other team in the police, or at least shared with the prosecutor in this matter. If, as a police officer, senior police officer, you sit with a case docket with evidence that's relevant to a murder matter, and a murder matter that's in the High Court, then certainly you're obliged to share this information, and apparently this never happened. So as far as that is concerned, that is a real worrying aspect of the handling of this matter by the South African police.
So with regard to that, Advocate Mshololo also saying yesterday that as far as she's concerned, she is now going to question how you have the first set of suspects in the first docket charged and the ones in the second docket not charged. So can we just address that with regard to the ND, the Director of Public Prosecution, South Gauteng, apparently having given the go-ahead that those in the second docket should be charged? How much do you know of this, and what should have happened?
I think we should put that into perspective. Apparently there's an indictment that was drafted but never signed. So if somebody reads a docket and you draft the indictment's only valid once it is signed off. So we have here an indictment in the current matter. Indictment in the current matter that was signed off by the Director of Public Prosecutions that the accused pleaded to. And then we have a different docket that apparently a different prosecutor looked at and drafted a different indictment. Now, that indictment, in relation to the one that we're dealing with, has got no value. And it's just a view of a prosecutor at the time reading a specific case docket. So what we have currently, we have an indictment based on a case docket that's before court, and the accused pleaded to this. If I can really give you an example, let's say, for instance, in that other case docket, Nel's name was there, and the prosecutor decided to prosecute Nel. He was not there, he's not involved. The prosecutor that read that docket, the second docket, the 2019 docket, decided not to sign an indictment, and that's my understanding. So what we have, and we have to place this into perspective, we have only one indictment. We have two case dockets, but one indictment. And the one indictment is the one that is currently on trial.
And this is as far as the investigation in the second docket has gone. So are we likely to see any further developments there, or should we read it as it stands to say that because that indictment wasn't signed, it most probably will not be signed?
Indeed, I think that is the inference you can draw. But what bothers me a bit more is that there must be some kind of hidden agenda, or a deliberate attempt to derail the trial. Because this doesn't make sense. It does not make sense that a senior officer in South African Police Service would sit with a case docket and have information in that case docket, and it's not shared with the other team within the South African Police Service, and even more with the prosecutor that's prosecuting this matter. Advocate Beloy placed on record yesterday that he'd been struggling to get hold of this case docket, and that he only received the case docket, I think, the day before, and shared it with Advocate Mshololo as soon as he had the case docket. Now, that is worrying. That is worrying why that case docket was not disclosed. I think those are the kind of questions we have to answer. We have to answer the questions of how this matter was handled in the police, by senior police people, and not so much on the current trial before us. Because as far as I'm concerned, the current trial before us, there's an indictment, there's a case docket, and the accused pleaded. And on what I've seen and what I've heard from the public prosecutor, there's a very strong case. And that case should just continue.
So speaking of this very strong case, do you believe that the 5 men who are currently on trial are actually involved in some or other way, or had been involved in what had happened in this murder?
Well, yes, I've been asked that question quite a few times. And of what I know, the facts that I've been briefed on, the address Advocate Beloy made to the court before the matter started, the evidence that he indicated he will lead during this trial, I think we have to correct the case before court. The mere fact that a different investigating officer had a different view that was not shared by any state advocate or any office of the Director of Public Prosecutions is just so. That's their view. This is an indictment signed by the Director of Public Prosecutions. And I'm not saying that what's happening at the moment in the High Court is not an absolute embarrassment for the criminal justice system. It is. It's an absolute embarrassment for the criminal justice system. It's an indication of the inept and unprofessional handling of this matter by the police. But I think we should just keep perspective of what we're dealing with. And I'm sure that more will come known. I don't know what's in that particular docket. Advocate Mshololo would certainly make clear what she's seen in the docket. And only then will we understand what the impact of this might have on the trial.
So with regard to the evidence that and the files, dockets that you have seen, do you believe, because Advocate Mshololo seems to believe that the occupants, or rather the people who were in the house that evening should equally be in the dock. So do you believe that there should be more people held answerable here in this trial?
I don't think she ever said equally. I think the version of the accused at the moment is that they have done absolutely nothing. That the 5 people in the house, that they should be charged for how many people in the house, they have done nothing. So that's what they're saying. I'm saying, and I've said so from the start, that I do believe that there should at least be one more accused in this matter, because my view of it, on what I know now, is that this was a contract killing, and that the person that set out the contract, that gave out the contract, is not before court. So I'm still of that view. Nothing changed my mind as far as my understanding of what happened in the trial. But I'm a bit concerned, especially when Advocate Thabo cross-examined, and he indicated that he's in possession of an affidavit of an eyewitness that would indicate that somebody in the house shot and killed Mr. Meyiwa. Now, if that is so, and if that was ever in the possession of the South African Police Service, and if that was never shared with the prosecutor and of the investigating team, I think it's absolutely serious and would need an urgent and immediate investigation on why that was never done.
And just to that question, because there were also questions around Advocate Thabo making that particular pronouncement. And now that he has made it, is he under any sort of obligation to now produce said witness to come and basically stave what he has said?
The word obligation is a bit harsh for a defense advocate. What I can say is, for the court to take that into account at all, it will have to be repeated by a witness under oath or the affidavit presented. So you can do lots of things, and I think we've seen it. I put to you that, and I put to you that. So you can put lots of things to a witness, but for the court to take account of that and take that into consideration, you will have to call a witness to back that up. So up until such time that there's a witness called to back this up, it's a mere version by the accused.
And Advocate Nel, you say you believe this was a contract killing. So the person, as you say, that you believe should also be charged, was that one of the people who were in the house?
I know you would try and get it out of me. I'm not going to do it, but a very good try, I must say. I applaud you for that. What I will, however, say is the following. I have a view on who the contractor is, or the person, the mastermind is. But my view was shared by the Minister of Police on the day of the arrest. The Minister of Police traveled all the way to KZN and informed my clients who the mastermind was. So I'm not alone in thinking who the mastermind is, but certainly I won't disclose who the mastermind is. I can't criticize people doing it, and then I do it myself. So, but a good try.
Well, thanks so much for your time this morning. And that, of course, Advocate Gerrie Nel talking to us about the latest developments in the Senzo Meyiwa trial. And Advocate Nel, of course, still there supporting the Meyiwa family, part of the family, and watching this with a beady eye.